Thank you, Madam Speaker. I rise to speak on Bill C-75, legislation that the government has introduced that purportedly is aimed at dealing with the backlog and delay in Canada's courts. The only problem, Madam Speaker, with Bill C-75 is it does next to nothing to deal with the backlog and delay in our courts. Indeed, more than likely, what Bill C-75 will do is do the opposite of reducing delay and actually increase delay in our courts. This bill was studied before the Justice Committee, and I attended all of the Justice Committee meetings in which we heard from a wide array of witnesses. And I can say that in the 3 years that I have been a member of Parliament, I have never been at a committee in which a bill has been as exhaustively and as comprehensively panned as Bill C-75 on virtually all aspects of this massive 300-page omnibus bill. This bill, Madam Speaker, does nothing to deal with delay. The government came up with this brilliant idea that so-called routine police evidence could go in by way of affidavit. The only problem with that is it would require a whole new application process that defense counsel would inevitably use, resulting in more delay, not less delay. Now, it's good the government has backtracked from that aspect of Bill C-75. They then came up with the other idea that preliminary inquiries should be limited to only those cases in which the maximum sentence is life behind bars. Madam Speaker, when I asked Justice Department officials whether they had any data, any empirical evidence to back up the assertion that preliminary inquiries were resulting in delay, their answer was that they had none. But Madam Speaker, I can point to empirical data that demonstrates that, in fact, preliminary inquiries do speed up the process and do reduce delay. Indeed, 86% of cases are resolved following a preliminary inquiry. That's statistical data. The government has none to demonstrate the contrary. And, of course, preliminary inquiries do provide an opportunity for counsel to clarify issues, to narrow issues, to test evidence, as well as there is an important discovery aspect to a preliminary inquiry. Moreover, it's unclear how the government decided to arbitrarily create two streams of cases. One where the sentence is life, in which an accused would be entitled to a preliminary inquiry, and then another stream applying to all other cases, notwithstanding that in many instances the sentencing guidelines or the sentencing ranges would be similar, but in certain cases the accused would be entitled to a preliminary inquiry. In other instances, they wouldn't. It speaks, Madam Speaker, to, I think, the very sloppy and haphazard way that Bill C-75 was drafted. But the biggest problem, Madam Speaker, with Bill C-75 is that under the guise of creating efficiencies in Canada's justice system, it waters down sentences for the most serious, among the most serious indictable offenses. What sort of offenses is Bill C-75 proposing to water down by reclassifying them from indictable to hybrid? Well, Madam Speaker, we're talking, among other things, about impaired driving causing bodily harm. Impaired driving, Madam Speaker, is the leading criminal cause of death in Canada, administering date rape drugs, kidnapping a minor under the age of 16, kidnapping a minor under the age of 14, human trafficking, arson for a fraudulent purpose. Madam Speaker, the government is moving ahead with reclassifying those offences. What is the effect of reclassification? Well, instead of a maximum sentence of up to 10 years, the maximum sentence would be 2 years less a day if they were prosecuted by way of summary conviction. Now, the Minister of Justice has repeatedly said, don't worry. Don't worry, this has nothing to do with sentencing. After all, the sentencing principles are the same. Well, Madam Speaker, of course the sentencing principles are the same, but when you're reducing the sentence and taking away the discretion of a judge to fashion a sentence from up to 10 years to 2 years less a day, I say, Madam Speaker, that that has everything to do with sentencing. And so, too, do apparently the Liberal members on the Justice Committee, because among the package of offences that Bill C-75 would reclassify included terrorism, related offences, as well as the offence of inciting genocide. I mean, it's just shocking to think that those types of offences would be treated or lumped into a class of offences such as a minor property offence, but that's Bill C-75 for you, a terribly drafted bill. But they, fortunately, at least in the end, listened to evidence saying that it would send the wrong message, that, as Shimon Fogel said, it would send a clear and unacceptable signal diminishing the inherently grave, even heinous nature of these crimes. He's from the Center for Israel and Jewish Affairs. The member for Edmonton Centre said, quote, and I'm quoting the National Post, "Let's be serious. We're talking about very serious offences," unquote. So much for the minister's assertion that reclassifying doesn't have anything to do with sentencing, doesn't have anything to do with diminishing the seriousness of an offence. It absolutely does, and the member for Edmonton Centre acknowledged as much. And Liberal MPs on the Justice Committee agreed when they voted with us on our amendments to remove the reclassification of terrorism and genocide-related offences. So I say, Madam Speaker, what kind of a message does it send then when we're talking about reducing and watering down impaired driving offences, or administering a date rape drug, or kidnapping a minor? Madam Speaker, it sends exactly the wrong message. It diminishes the seriousness of those offences, and it makes it possible that individuals who are charged with such offences could walk away with literally a slap on the wrist. Such offences have no business being reclassified. They have no business to be left to a prosecutor somewhere in some office to make the call without any level of transparency, without any level of consistency. Madam Speaker, it is absolutely the wrong way to go. And by the way, Madam Speaker, in closing, it will do nothing to reduce delay. Why won't it? Because 99.6% of cases are already before provincial courts. We know summary offences are before provincial courts. It means more downloading onto overstretched and overburdened provincial courts. It won't reduce delay, but it will water down sentences, undermining victims and undermining public safety. Madam Speaker, this bill needs to be defeated out of hand.
Questions and comments? The Honourable Parliamentary Secretary and the Minister of Justice and Attorney General.
So one comment and one question, Madam Speaker, and I thank the member opposite for his work at the Justice Committee. He talked about delays, and what I would put to him is that when you take administration of justice offences and you no longer apply criminal charges to those those issues, but you instead create a judicial referral hearing, you avoid clogging up the criminal justice system which is a goal that the member opposite and I would both share. But the question I have to him is that he put forward a lot of important comments with respect to victims and how victims are treated under this law, and what does this bill do for them. What I would say to him is about those very women that he referenced, what we are doing in this legislation. Would he agree that what we are doing in this legislation, by defining intimate partner violence to include dating and former partners, by increasing the maximum sentences for intimate partner violence, and by enacting a reverse onus on bail for repeat offenders, does that not protect the very victims who are women that the member opposite seeks to advance in terms of his own position in this House? Thank you.
Our member for St. Albert, Edmonton.
Thank you, Madam Speaker, and I do support the parts of Bill C-75 related to intimate partner violence, and we supported that at committee. But unfortunately, much of the rest of the bill is a mess, and the members spoke about AOJ offenses, administration of justice offenses. The bill seeks to do something about those, but the reality is that administration of justice offenses actually take up very, very little court time. Why is that? Because in almost all instances, if someone, for example, breaches bail, there's a substantive charge underlying that. And so typically someone is not brought back into court until the main charge, the substantive charge, is dealt with. So while there was a lot of talk about administration of justice offenses, the reality is very little court time is specifically devoted to them, and that evidence was clear before the committee.
Questions and comments? L'honorable député de Joliette. Excuse, de Jonquière.
Merci, Madame la Présidente. Je voudrais revenir plus sérieusement. Dans son propre rapport sur les consultations auprès d'intervenants, le ministère de la Justice reconnaît que les enjeux sociaux sont en grande partie responsables du fait que notre système est surchargé. Il y a presque tous les participants à la table ronde ont exprimé les mêmes préoccupations majeures. Ils ont dit que presque toutes les personnes qui ont des démêlés avec le système de la justice pénale sont des personnes vulnérables ou marginalisées. On voit beaucoup de problèmes de santé mentale, de toxicomanie, de violence. Donc, j'aimerais ça avoir l'avis de mon collègue concernant est-ce que le gouvernement devrait investir davantage auprès des causes fondamentales de l'inégalité sociale et de cesser de criminaliser les personnes qui ont besoin d'aide. Merci, Madame la Présidente.
Yeah, member for St. Albert, Edmonton.
Well, what, Madam Speaker, this government should do is invest in Canada's justice system by giving the actors within the justice system the tools and resources that they need to deal with the backlog, including the prompt appointment of judges. The parliamentary secretary can talk all he wants about how the minister is now appointing judges. Well, the reality is that under this minister's watch, she failed to appoint judges for 6 months upon being appointed as Minister of Justice. She has seen judicial vacancies reach record levels. It is the responsibility of the minister to fill judicial vacancies in a timely manner. Her failing to do so in the face of Jordan, upon which cases are at risk of being thrown out of court and indeed are being thrown out of court as a result of this minister's inaction, it is not just inexcusable, it is negligence on the highest order.